So Chris and I have been talking about where we are with legislation, and we are going to dive into everything that's been going on in Wyoming, but we thought we'd start out by looking around to see what kind of laws are being passed around the country. And we found really there are four groups. The first pertains to what we probably all know about, which is the money transmission laws. And those laws tend to be.
If you make sure you're muted,
Where we are, can you please unmute? We are going to dive into everything around to see what kind of laws are being passed around.
there we go.
All right, thanks. We need you to mute. We want to hear from you when you're not speaking. Mute your phone or your computer, please.
Yeah.
So the first group is really something we've been hearing about on and off. Has to do with money transmission.
Mm-hmm.
Those money transmission laws and whether or not virtual currency is or is not covered in the definition of money.
Yeah, money transmitter laws exist in most states except for Montana for the purpose of protecting consumers and making sure that when you send money to someone that your payment's protected. It also has some BSA AML relevance too. But crypto is digital assets, I should say. There's money in certain legal contexts and money in certain other legal contexts, and states are just kind of now getting up to speed on how crypto fits into money transmission laws.
Exactly, and not only money transmission laws, there's a trend in many states that are looking at how cryptocurrency fits into other types, into the definition of property for a whole different group, a whole different array of laws, such as escheat laws.
Yeah.
I mean, anywhere the state is trying to tax or to collect on property or values related to property, the state tends to be including cryptocurrency in their laws. So the 2016 revised Uniform Unclaimed Property Act now includes virtual currency in its definition of property, and this law has been adopted by Illinois, Colorado, Kentucky, Nevada, Tennessee, and Utah. And I think there are many others that are looking at that. Did you have a thought about that?
Yeah, no, it's just kind of strengthening the kind of the fundamental truism I think everyone's aware of, that digital assets are a form of property, and you're able to pass them along to your descendants and to transact with them or deliver them to your relatives in a way you normally would.
Yeah, and just to that point about the decedents, the amendment to the Uniform Fiduciary Access to Digital Asset Act that expressly authorizes that an estates executor can manage digital assets, including virtual currencies of the decedent. That was passed in New Jersey, so we've got New Jersey focused right on that. And the money laundering laws. Florida's Money Laundering Act was amended to include a definition of virtual currency that expressly prohibits the laundering of virtual currency. So we see there's this recognition of cryptocurrency as property.
Yeah.
The other buckets or types of laws that are being passed around the country. The very first law really pertaining to virtual currency and blockchain was in New York with a BIT license. And that's still on the books. And just recently, Louisiana passed a law. It's Virtual Currency Business Act. It's a bit of a skinny down version, but again, they're trying to regulate.
Yeah.
And a lot of people have very visceral reactions to these type of laws.
Yeah. I
know that what I've heard speakers in New York talk about from the public sector talk about BIT license. I mean, they say that this law is important because it protects their citizenry, protects their interests. Of course, others would say it stifles innovation, and everyone has their own ideas about these laws. But that is something that has been passed, and people and jurisdictions are considering. But yeah, so that's but Wyoming decided not to go down that route.
Yeah, kind of the I hate to use the word legacy, but the other regulatory frameworks that have emerged, just they've been, just hadn't had as much detail about how the digital assets should fit into the existing financial system. So Wyoming's tried to really strike a balance between promoting consumer protection and responsibility on behalf of the financial entity, at the same time promoting innovation and providing an enabling legal framework for people to know that, if you meet these standards, you're going to have certain legal protections. We're not trying to be prescriptive, we're trying to be enabling. And
exactly.
Yeah.
And that really leads to the fourth category of legislation that's being enacted around the country. And these are laws that create the regulatory infrastructure to engage in commercial transactions, investment transactions involving digital assets, usually cryptocurrencies. So this is largely the legislation that's been enacted in Wyoming, but also other states that have enacted laws regarding signatures, records, contracts, all that use blockchain ledgers.
Yeah.
And many of those were right out of the gate, early on. I'm thinking Nevada and Arizona especially.
Yeah.
And what I think about when I sort of think about all these laws that have been passed really in the last maybe 5 years, not much more than that, and many of them in the last 2 or 3 years, is that this proliferation is something that we need to pause and really recognize that this is remarkable. Mm-hmm. Because you have so many jurisdictions that are really in a relatively short period of time recognizing, as you said, digital assets as a new form of property with value. What I was just saying is that when you have so many different jurisdictions passing an array of laws that pertain to blockchain technology, cryptocurrency, that's just something to sort of sit back and go, wow, that's pretty remarkable. And we can't, people who have come into the space in the last year and a half, they may think that's how it always was, and that's pretty standard. Like I said, folks who come in may not realize that it wasn't always that way. And in fact, in the beginning, in the early days, and I'm saying like 5 years ago, people, when they thought about crypto, they thought about the dark web. And there was a lot of concern here.
Drugs,
money, all of that, money laundering. So, in a way, it makes sense that in 2015, New York passed the BIT license. They're looking to regulate, and then yet in 2016 and 2017, there's a different turn taken, a different approach taken with Vermont and Delaware. And we were talking with Oliver Goodenough, and he actually had a hand in this, and his colleague David Thielander as well. And we may be hearing from them a little bit later on, because they've done some really innovative work in the blockchain space.
I think it's remarkable, Andrea, on one point you made.
Yeah.
In 2017 was kind of the realization by the market, I think, that this could be another financial asset class.
Right.
We think about digital assets, within kind of existing legal structures, and digital assets are definitely a unique and innovative asset class, but at the same time, there's certain common features that digital assets share with other asset classes that kind of they're different and alike at the same time. So the real trick is trying to thread the needle and kind of balancing both aspects.
Absolutely. Well, when you talk about they're alike and they're different, and I think that's what we're going to get to when we talk about Wyoming. We say they're property. Yeah. And what does it mean as lawyers, we all learn, in our first year, what does it mean to possess property? The ability to exclude others, to be able to control. But of course, that is seen through the prism of a digital asset, blockchain tech distributed ledger. It sort of takes on a different tone. So we'll be talking about that. Yeah. So we were starting to say that in 2016, 2017, the shift was in focus. And in fact, the legislation that came out of Delaware and Vermont and Delaware, I should say, was really underpinned by this idea that blockchain technology is actually a legitimate technology used for good, right? Yeah. To be able to, and then that evidence or that information coming off of a blockchain ledger, a signature of a contract, and information, this is something that should be, that is legitimate. And in 2016, for example, the Vermont Assembly passed a bill that allows blockchain-based evidence to be used in court. Yeah. And it's, and I think it was the idea that a timestamped on a blockchain, that a document timestamped on a blockchain, it should be considered a record of regularly conducted business when considered against the state's rule of evidence. So the idea was really to say, listen, if a party uses evidence that was generated or blockchain-based, generated on a blockchain through a blockchain-based ledger, it can't be challenged.
Yeah.
And it shouldn't be
Or
challenged.
it's admissible. It enters the court from a presumption.
Exactly, presumption of, exactly, through the presumption.
Be rebutted.
And that's kind of a big deal, because again, before that, if you walked into a room and you said something about crypto or blockchain, it would be pretty negative, especially at that time. So kudos to Vermont and to Oliver and to David and all those involved with getting that law passed.
Yeah.
And frankly, this through line continues into Delaware the following year, because it was in 2016 when, and I was working for the state of Delaware at the time, when we started thinking about blockchain technology. And then the following year in 2017, the Delaware legislature enacted, and the governor signed into law SB 69. And that permitted Delaware corporations to use distributed ledger technology in the administration of corporate records, including stock ledgers. Again, you say, well, why is that so important? And why do they need to do that anyway?
Yeah.
And frankly, the reason why they had to do that, or they didn't have to do it, but we had gotten requests, and the idea was that companies wanted to issue shares, or if they were to issue shares on a blockchain and maintain their stock ledger on a distributed ledger where you didn't have one person making sure the records, as they had been for 100 years, making sure those records were correct, that if you didn't have that legislation and you went to put that your stock ledger on a distributed ledger, you could be found liable.
Sure.
Because it was in the words, the express language said an officer of the corporation had that responsibility.
Yeah.
So again, you see this shift towards creating and enacting legislation to enable folks to use blockchain technology without concern. Mm-hmm. And what that actually did, was, and I don't think unknowingly, maybe knowing or maybe not, but it really put the state's imprimatur on the technology. Again, legitimizing the technology. And for the state of Delaware, I mean, corporate filings and corporations,
the budget.
That's a big part of the budget.
$1 billion.
And it's a big deal. So, here you have the state, and it wasn't just the state, the lawyers. It was really the lawyers that were asked to consider. The lawyers in the Corporation Law Council considered the issue, and they agreed to take it up, and they agreed to amend the law. They thought it was important.
Sure.
And they knew what they were doing. So you have this legislation that got passed, and then the world knew that, as far as Delaware was concerned, the blockchain technology was legitimate.
Sure.
Right. So that was 2017, and then what? Cambrian explosion, right? Yeah. We saw so much legislation coming from all different places, and frankly, I was a little skeptical. Along with a colleague, Josh Clayman, we wrote an article like, "Do we really need all this legislation? Like, why do we need all this legislation?" Yeah. And yet the legislation proliferated, right?
More bad than good, probably, right? I think during that time I saw 20 or 30 different definitions of what a blockchain was.
Right, or the importance or legislation saying that smart contracts should be enforceable. Okay.
Okay.
It's code. It's code, everybody. Yeah. It's code. Yeah. So but what that led to was Wyoming really getting involved. Yeah. And of course, Caitlin Long was a big part of that. And you were a big part of that. So
maybe. It remains to be seen.
Yeah. So in the very beginning, and I know some of our other presenters today have spoken about some of this legislation, so we're not going to dive into detail, but we did start to see very innovative legislation. Mm-hmm. And frankly, I think a little provocative, because the first legislation out of some may say even that the first legislation out of Wyoming usurped some of the authority, or was seen as to usurp some of the authority from the federal government. What say you, Chris?
Yeah, what say me? No.
We're talking about the security token, utility token legislation.
Yeah. So the first bill that kind of got the world's attention was House Bill 70 in 2018, the Wyoming legislature. It established a certain set of legal standards for certain consumptive tokens. You may hear them referred to by the term utility token, but the Securities and Exchange Commission definitely doesn't like that term, so we're not going to use it. But the reason Wyoming did that was
Well, can you just step back a second? Talk when you say consumptive token utility, because these days you don't hear that term bandied around. But in 2018, that was a big deal. That was sort of an issue that was out there. Which tokens are securities? Which tokens aren't? If they have a consumptive purpose, are they? Does that mean they're no longer a security? And of course, we learned, the SEC made that very clear. So tell us a little bit more what you mean by that.
I wouldn't say that the SEC's made it very clear.
Well, they made it clear. They provide clarification.
Not even clarification. I would say they've made comments on how they view certain certain issues. I'll take the question in a second. Let me finish my thought. So Wyoming's framework established, certain factors around if the token's available for use at the time it's made available, if it has a genuine consumptive purpose, and if it's not marketed as a financial investment, it's classified as a consumptive token.
And they can use it at the time, right?
And they can use it at the time. The reason Wyoming did this was in Switzerland and in the UK and in the European Union and certain other jurisdictions, they've started rolling out new property frameworks and new financial frameworks for digital assets. And in each of those jurisdictions, they recognize a security token, virtual currency, and a utility token. So Wyoming actually hasn't gone any further than other, jurisdictions that have, respected financial systems in doing utility token law. The SEC released some guidance on, investment contract analysis for digital assets.
Sure.
And it certainly had some comments on consumptive tokens. It wasn't entirely clear. My own personal view is Wyoming has walked right up to the line of what's permissible, but
sure.
I think we're on the right side of the line. Just another thing, I'm going to take the question real quick. It's about, are you talking about XRP when you say utility token? No, XRP is not a utility token. That kind of falls more into the virtual currency arena. When I say utility token, I'm talking about purchasing access to cloud computing networks, things that are not freely tradable on the market. XRP is obviously tradable. I'm talking about, tokens you can redeem with a particular token issuer to receive some genuine consumptive
service,
good, a household good, a service, that kind of thing.
Yeah, and one of the things that I think when we've talked about why Wyoming decided to pass that legislation is that you were really creating a roadmap not just for Wyoming, but to say this is what we think about digital assets, and we think it would be smart to have a classification system,
like the European regulators.
Exactly, and there's nothing that prohibits the state from doing that. And really, we talk about sort of the states being, I think, like the incubators for the innovation, the laboratories, right?
Yeah.
Exactly. So, and I think we're seeing that that's actually the case, that this is proving out.
Yeah.
And because that very first piece of legislation really paved the way, or started Wyoming down a road to expanding on that notion and classifying.
Colorado and Montana have since enacted our consumptive utility token law. So it's not just Wyoming anymore, and other states have looked at it too. So.
Exactly. So you were on the right on the right road.
Yeah. Okay. Should we move on to some of the other Wyoming?
Absolutely. Yeah. Well, what would you like to? We can talk about some of the other legislation. If you want to jump into the UCC piece, that gets a little hairy, and this is a spoiler because our hypothetical at noon is going to involve some of the issues we're talking about here about UCC and priority. So I pay attention if.
Lawyers will get some special fascination from our hypothetical at noon, so definitely encourage you to tune in on for that.
Yeah. So let's jump into that.
Yeah. So I'll start with the bank,
sure,
and then we'll go to the UCC.
Yeah.
So everyone knows that banks are kind of the trusted intermediaries of the world financial system. All the largest financial entities in the world either are generally a bank themselves, or they have a bank somewhere in their corporate structure, their holding company structure. So banks are heavily regulated, and they're heavily regulated to make sure that there's consumer confidence in banks, to make sure that they don't endanger the national and international financial system, and make sure you get your money back when you entrust it to a bank, right? So Wyoming's thinking beginning in 2018 was there really wasn't going to be traditional finance acceptance of digital assets until digital assets were merged and blended safely into the U.S. banking system. The way that was accomplished was a new bank charter option was enacted in 2019 that
in Wyoming.
In Wyoming.
In Wyoming, right here.
And it's a Wyoming state charter bank that serves much like a custody bank, like State Street or BNY Mellon or JP Morgan Chase. Its primary role is to serve as a trusted intermediary in the financial system, to hold on to client assets and to safeguard them, and to provide a trusted regulated partner to do certain commodities and securities transactions.
And importantly, not to do any lending, right?
Yeah, not to do any lending of the on-balance sheet assets.
Right.
They can do traditional securities lending activities,
Sure.
like virtual currency and security tokens and that kind of thing, but that's off-balance sheet, and
Right.
It's structured in a different legal way.
Right.
So the bank can lend, but it's all off-balance sheet. And to do that, Wyoming also had to enact a certain other set of laws, two in particular. One is lovingly referred to as Senate File 125, that established standards around digital asset custody and regulatory expectations about consumer protection, source code version changes, how to do capital markets transactions with digital assets in regulated markets. Disclosures, accounting and audit stuff, and the liability of the bank and the customer for the transactions. And the second piece was Wyoming. Wyoming had to make some clarifications to our commercial laws to specify, what is virtual currency under existing law? How do you take a security interest or a lien out on virtual currency?
Keep on going.
How do you take a lien out on virtual currency, and what would happen if the custodian went down, and what kind of priority would those liens get in the receivership? You really can't do like standard market transactions without having all that clarified. Folks today in the digital asset markets they're either using a version of our commercial laws that doesn't really line up completely with digital assets and kind of limits their utility in some ways, or they're taking a large amount of legal risk.
So Chris, let's unpack that.
Yeah.
Because there's a whole lot there.
Yeah.
And a whole lot there. Yeah. And frankly, we could probably talk about this for hours and hours and hours. Yeah. I mean, it's just incredible. Yeah. But given we have really, a half hour more. Yeah. So let's start out with
there's a streaming which comes in through that website, and then you can also click in through Zoom.
Okay.
Hey, Oliver, there we go.
All right, cool. All right. So let's take a deep breath. There's a lot there. So in the first part, you were talking about sort of the rules of the road for the bank, right? Yeah. And protections for consumers. So if a consumer had, let's say, a consumer had certain cryptocurrency they wanted to put in custody, and then there was a fork, what happens, right?
Yeah. See,
I mean, that's something that, and right now, there are companies that take custody, that are custodying these cryptocurrencies, and they all treat it a little different, right?
Yeah, and tons of companies today are holding on to the fork. When a digital asset forks, they're just holding on to it and saying, more money for me.
More money for me. But that's not what you did in Wyoming.
Yeah, that's not what we did in Wyoming.
You took the fairest. It sounds like, just from what I remember, the fairest, most reasonable approach. So maybe you could talk a little bit about. Just pick a couple of examples.
Yeah. So on the fork issue, institutional money, not having those protections in place isn't enough for institutional pension investors or other institutional funds. There has to be clear treatment and fair treatment. So like for a fork, there should be clear agreement in place between the customer, and the customer should have certain rights toward the fork assets unless they want to use them in other ways.
Right.
So as far as consumer protection, we addressed forks, we addressed airdrops.
And talk about airdrops.
Okay, they are required to make we call them subsidiary and ancillary proceeds. They're required to make those new assets available to the consumer unless they have certain other agreements in place.
So basically, what you're saying is consumers who are using a bank, one of these Speedy banks in Wyoming, they're going to get the benefits of these fortuitous events that happen that enrich the owner of the token.
Yeah.
If they weren't using a custodian.
Yeah.
They get the benefit. So you looked at all of that.
Yeah.
And you said there's an airdrop, there's cryptocurrency coming into your account, you get that. There's a fork, you get that, right?
Yeah.
You get it. And frankly, I think there were some rules around the bank can't do stuff with your crypto unless you get permission. So maybe you can sort of talk about that.
Yeah, and that's another great piece or part of the consumer protection issues. Traditional banks, when they take on your asset, their custodial assets, they have certain rights to do securities lending transactions, and many times it's without your knowledge. And virtual currency is kind of different than the securities world or the traditional securities lending world, mainly because there's no lender of last resort for Bitcoin, for example. So if there were to be more claims on Bitcoin than there were assets available, it could start a systemic financial issue in the markets. So we have in our laws to protect consumers, we've allowed digital asset lending, but it has to be under certain conditions, and you have to expressly authorize it. It can't be done.
The customer has to expressly authorize. So the bank can't just take your crypto and lend it out and earn a little money for lending it out and then
get leverage.
They just can't do that. That just doesn't. I mean, they can make a deal so that the bank can do it, but then everybody knows what's going on.
Yeah, and when the customer asks, and certainly the customer has every right to try to make more money off their Bitcoin.
Right.
Like absolutely.
Right.
There are many strategies and where that comes into play, but we're just trying to make sure there's a fair exchange of information between the customer and the bank. The customer has to accept the legal risk and under most cases, be fully informed on the terms of the transaction. On the other hand, the bank has to do, bank quality trade execution, provide all the information to the customer and do their best to safeguard the
And Chris, there's another very important feature of this bank, which I know has gotten a lot of coverage, but I think it's really important for you to address that. And that when a customer uses a Speedy Bank, they may be turning over their keys, right? But they're not turning over their ownership, right? There's a Bailor-Bailey relationship. And this is really significant because this is so very different than the current practice under Article 8 right now, when you turn your shares over to a securities intermediary. So maybe, can you just address how what Wyoming is doing is just a little bit different and probably just a little bit better?
So under existing securities laws, you have a claim to a security that's held by your intermediary, whether it's a bank or a broker dealer or whatever. You have a claim,
and you don't own it directly.
But you don't own it directly.
You don't own it directly.
There are several layers of ownership that are between you and the actual certificate or electronic certificate that exists in the bowels of some building in Manhattan. But in Wyoming, instead of that claim to an asset that you don't directly hold, in Wyoming you have a direct property relationship to your virtual currency or your other digital asset, and that gives you stronger protections in bankruptcy. If your custodian were to fail, you would have stronger property rights, and it also gives you kind of more of a sense of value, I think, as well. I think we had a question.
Yes, very good.
Couple questions. The first question is about how will banks compete with yield farms relating to all the decentralized finance apps popping up that can't leverage their clients' assets? And I think these are separate markets. First of all, I think DeFi especially is a very new phase. It has
phase or fad.
Phase or fad, depending on what my mood is at one point or another.
Right.
DeFi, it hasn't really matured to the same level as other digital asset markets have. I think we're talking about different markets. These banks are going to be primarily engaged with more mature institutional investors who see Bitcoin as an alternative asset class and have certain legal obligations to hold their assets with a custodian, whereas I think the DeFi space is still emerging. And then another question that talks about rehypothecation. So rehypothecation is one of the primary things that we address.
And just define it real quick for everybody.
So rehypothecation means I lend Andrea my Bitcoin, and then Andrea takes the Bitcoin that I've lent, and which she owes to me, and then lends it to somebody else. And in the capital markets on Wall Street today, rehypothecation chains can extend, dozens, hundreds of.
And that creates a lot of risk in the financial markets.
Yeah, it creates a lot of risk. The alternative side of the argument is that it provides more liquidity and more opportunity for gains. I think there's some competing policy arguments on both sides. But for digital assets, especially, rehypothecation is dangerous because there's a finite supply of Bitcoin, and if there were more claims, there could be a systemic financial
And
issue.
so you actually made and if I believe correctly, under Wyoming law, rehypothecation is illegal. Is that right? Is that my understanding?
Relating to our digital assets, it's rehypothecation is not permitted for digital assets.
Okay.
So it's you can lend your virtual currency once, but the bank has to take steps to make sure that the person they're lending it to isn't further lending it.
And the speedy and under the legislation that you enacted, I think rehypothecation is clearly not permitted.
Yeah, exactly.
Clearly.
Yep.
So thank you for that question.
All right, so why don't we keep plugging away?
Okay, so we're going to talk now about the UCC question, because what you were talking about is you've got digital assets. We talked about earlier, we've got digital assets, we've got something of value, right?
Yeah.
And so we talked about the states, they recognize it's a thing of value. So now we have lenders who are going to recognize that someone's digital assets are a thing of value, and they're going to seek to take a security interest in those digital assets, in that virtual currency.
Sure.
And right now there is a method for this within the UCC, because virtual currency, cryptocurrency would be considered general and intangible.
Sure.
And a creditor would be able to perfect her security interest by filing a UCC-1, where the debtor's located, right? But Chris, you didn't stick with that.
Yeah, there are a number of problems with that approach, and there's an alternative approach, which I mentioned too. But UCC, I don't know if there are any folks who are engaged in digital asset lending, listening, but I don't know. Maybe your lawyers have told you, but you have to file a form with the Secretary of State in certain jurisdictions when you take a security interest or lien on someone's digital asset. If you don't do that, you don't really have any rights to enforce your lien.
You mean the priority? You mean as opposed to, as against others?
Yeah, exactly.
As opposed to the debtor, you certainly have, but as opposed to others, if you don't file, you haven't put the world on notice, and they don't know that you've got a security interest.
So your rights aren't as strong as they could be if you file the UCC-1. The alternative way is to do it under Uniform Commercial Code Article 8, and to have the virtual currency or the digital asset held in a securities account, and it would receive kind of the same commercial law treatment. And so the UCC Article 8 option is permissible too. Wyoming's approach was, we focused on a couple of things. Virtual currency has to have for it to be really effective in the markets, it has to have certain negotiability aspects. And probably the most straightforward way to promote that negotiability was to classify it only for the purposes of UCC Article 9, which is the security interest part of the UCC, to classify it as money for the purposes of UCC Article 9. Wyoming hasn't declared virtual currency to be legal tender or to be equivalent to the US dollar.
Just for the purpose of secured transactions under Article 9.
Yes, and it has that negotiability where if you were to take, if I were to give you Bitcoin and you take it without, knowledge of, anything wrong that I've done, and you purchase it for value, you generally I'm
free and clear.
You take that
free of any claims.
Yeah.
Right.
Without that negotiability, you might not have the same strong property rights in that digital asset. That's what Wyoming. That's one of the major things Wyoming did. We also permitted. We also permitted possession or control of virtual currency to take place through a smart contract, under certain standards, of course. But if you were to take possession through a smart contract, presumably the smart contract would be created with, or could be created with, the custodian. Right? That's probably the best way to do it.
And the debtor, right, would probably keep control of the crypto to the through the smart contract to the custodian.
Sure. Yeah. Still have certain rights relating to the virtual currency, but all this is important. We're getting down in the weeds, but all this is really important because the Uniform Commercial Code and our other laws is kind of the plumbing of the U.S. financial system.
Sure.
And without clarifying certain things, it's really difficult for it to be fully integrated into our financial system.
So just wrapping this up a bit, Chris. we have in most states, you can, and in every state, you can file the UCC1 and take a security interest, but Wyoming created a new way of taking a security interest in digital assets, right? And that's a possessory security interest. And so if you say, well, it's not just that the creditor takes possession. There are a few other hoops that need to be jumped through. Can you just sort of elucidate for us, how does a creditor get a possessory security interest in a debtor's crypto, let's say?
Yeah. So a possessory security interest is kind of a longstanding commercial law concept where the creditor, the secured creditor, actually is taking possession of the keyboard. They have a security interest in the keyboard, and they're actually taking physical.
They take control. They take it away.
Yeah, we have to be careful to use the words possession and control in the right context.
Yes.
But they're actually taking physical possession of the asset they have a lien against.
Right.
And the reason that Wyoming thinks there's substantial analogies to virtual currency is because what do you need to dispose of virtual currency?
You need the keys.
You have to have the private key.
Yeah.
And in that way, it's a lot like a bearer asset or bearer instrument.
Sure is.
It's a lot like a bearer instrument, and that having that private key is the best way to exclude others. It's the only way to exclude others, right?
That's right.
If you drop it on the sidewalk, someone may or may not steal all your Bitcoin. But so in that way, there's substantial analogies to a possessory security interest. And interestingly, we're going to get into this in much greater depth in 15 minutes or so. We want to leave some time for questions. But interestingly, with a possessory security interest, the law where the collateral is actually located would govern, and not the location of the debtor.
So just that's great. Just one follow-up question. Under Wyoming law, how do you determine where the asset is located?
So this is another challenging concept. The UCC, the Uniform Commercial Code, struggles to place a location for intangible assets. But again, since a private key is a lot like a bearer instrument, it's more analogous or more susceptible to having a location. So we established kind of a multi-part test in Wyoming law that judges can use to
determine,
feel more comfortable that there's a substantial nexus to a place like Wyoming, that the digital assets located in Wyoming. It's definitely not that simple.
But Wyoming is not the only jurisdiction or the only group or organization that has sort of been looking at possessory interests or taking possession and taking control and deciding where things are located. I mean, we're seeing other people and other groups opining on that. Courts are opining on that as litigation is arising. And so this idea that the location is where the keys are is not unique to Wyoming.
No, there's been some judicial precedent on the fact. There's been some Bitcoin, wrapped up in judicial proceedings over the last couple of years. And interestingly, the CFTC's approach to how they're looking at digital assets like virtual currency is, more consistent with Wyoming than it is consistent with the Uniform Commercial Code, because they recognize both possession and control. And you have to have possession and control of the virtual currency. They're different bodies of law, so they're not exactly analogous, but it is somewhat indicative.
And the other thing is, if you just sort of think about it, sort of a practical approach to, obtaining a security interest and what a best practice is, having the keys, that'd be a good best practice. Well, listen, we're getting to that time, and I see Russell, and I just want to call out Russell De Silva, from an attorney and friend, UCC expert at Pillsbury Winthrop, because he's been working with us for a while, talking with us, and actually he had a hand in helping us with the hypothetical that we'll be doing shortly on the UCC side. So I want to say hi to Russell, call out to Russell. But does anyone have any questions, comments on anything that we've discussed this far?
And production staff, if we could show the person asking the question when they're on the screen, that'd be awesome. If we can't, we'll just do our best. So,
and you know what? Actually, before we get to the questions, we forgot. I want to bring to ask David and Oliver from Vermont, because they're doing some really cool things, and I wanted them to talk briefly about their blockchain LLC. They passed this legislation, and maybe they could talk about that just briefly and tell the group about that. We really didn't want to forget that, the BBLC and the And there's also some legislation they passed
Personal
about
information
the
protection.
personal information protection. If you could just take a few minutes, and then we'll answer questions, and then we can, of course, answer more questions as we slide into session 2. So David and Oliver, can you just give everyone an update from Vermont? Thank you.
Sure. Thank you so much. David, you want to do PIPSI and I'll do BBLLC, or vice versa?
Yeah, why don't you do BBLLC, Oliver, start first, and then I'll follow with PIPSI.
Okay. We in Vermont, where we've also had some attention to legislation around the blockchain, we, like Wyoming, have focused in on laws that states control. The questions of securities aspects are typically done at the federal level, but the states get to set all kinds of property regulation. They also get to set business organization regulation. And one of the things that we've done with the Vermont law here is to authorize a special kind of LLC, the blockchain-based LLC. The point of this being, as Andrea was saying earlier, not so much that maybe we couldn't have done it with a regular LLC, but if you actually set it out there and set up something that specifically says what you can do, then people can take comfort in that. And the BBLLC essentially gives a landing spot in the legacy legal system for various kinds of on-chain activities. It could host a cryptocurrency. It's being used to host a number of DAOs at the moment. Because it will work on that way. There is some paper-based filing that you need to do originally, including some information on aspects like your what you're going to do about forks and what your security protocols are and that kind of thing. But then once you've got that bit of paper done, and you can have an operating agreement which then basically elects to transfer all governance over into on-chain mechanisms. So it's quite permissive of on-chain governance. Again, there's arguments back and forth as to whether current LLC laws around the country would allow that to happen. Maybe we make it explicit, and we've seen some uptake, as I say, particularly in the DAO space, where this has provided the comfort for folks to go forward with a governance structure of essentially all through an on-chain activity. David, do you want to talk about PIPSI for a moment?
Yeah, thank you, Oliver. So I'll keep it brief. So the PIPSI, Personal Information Protection Company Framework, was adopted in Vermont back in 2018, and and Oliver and I were advocating, and we've brought several clients forward in Vermont to work with the regulator there, the Department of Financial Revenue. The framework basically works like this. If you're a company and you're dealing with and holding PII, the framework allows, and we think it's still at least close to first in the nation, a company to basically raise its hand, say, in the course of our business, we are holding PII, and we are basically, and we have submitted an application to the Department of Financial Revenue. There's a series of questions in the application process, and then essentially DFR issues a certificate that says you've adopted effectively that PIPSI framework. So to use Oliver's phrase a couple of years ago, for companies looking to come down on the side of the consumer, it's a great framework to say, hey, we get it. This is why we undertook this process in Vermont, and we've got this, again, application submitted and approved by the DFR accordingly.
One of the key elements of that bargain with the state is that the companies electing into this agree to give a fiduciary duty to the consumer over their data. Which sort of flips over the customary fiduciary duty in a company, which is to the shareholders and its side. Now the company says that in fact we will the customers' interests first. That doesn't mean they can't do deals, but the deals have to be explicit and have to be fair to the customer.
That's opening up a can of worms there.
It is.
Well,
wow.
this is it's voluntary. Again, what the idea is that this sets a gold standard that folks can opt into rather than one that they have to. But if companies really want to say we're your friends when it comes to your data, this then makes them nail their colors to the mast. They can't back out of it.
Okay. Thanks.
Yeah, and a little bit of background on this is Vermont being a small state like Wyoming, very small population. I don't know if there's still more cows than people in Vermont, but there may be. The state got hit relatively hard by all those credit breaches back in the, that continue to be. So Vermont's really has wanted to take a very firm stand on this, and the PIPSI is part of that. Briefly, there's also a data privacy and breach reporting statute in Vermont that's separate but related, but that's where Vermont is. So
okay,
thanks.
well, listen, I'm gonna jump in and say a big thank you to David and Oliver for the update from Vermont.
So
We're having
Thank you in return.
Yeah, thank you.
yeah, so we do have a question from Brendan. He asks, what if only one multi-sig holder is in Wyoming? This is an interesting question, and like the presenter before me, I'm not going to provide legal advice, but I will say, parties to a contract have certain rights to opt into Wyoming law and to access the advantages of Wyoming law in their contracts. They can stipulate to certain provisions like multi-signature arrangements. We actually do recognize multi-sig arrangements in certain cases in Wyoming law, with the caveat that to have legal custody of an asset, it may depend on how many multi-sig participants are, what the legal relationship among the multi-sig participants is. Like, do all the multi-sig participants work for the same employer or for the same organization or things like that?
But Chris, is there a requirement that, I don't think there is, but you can tell me if there's a requirement that all the multi-sig participants need to be in Wyoming?
No, I don't believe so.
I don't think so either.
Yeah. All right. So why don't we open it wide open for questions? I guess we have another question here about escheatment. You want to handle that one?
It says, I'm curious about multi-sig too, especially for escheatment. And escheatment, frankly, is raising all sorts of issues because for those of you, just to provide a little background, escheatment occurs. It's basically the right of the state to collect property that has been left without anyone claiming that it's theirs. So people have talk about crypto that's on an exchange, and actually in some states I think it could be 3 years that the property has been left, I guess unattended or without anyone taking it. So it raises a lot of questions about if you've got a crypto on an exchange that's been there for more than 3 years. Does that mean that that property has been abandoned? And if so, which state gets it? Generally, the state gets it if you know who the owner was supposed to be and you contact the owner and you can't find the owner. So really, there are a lot of issues there when it comes to escheatment. Although with the multi-sig question, it is an interesting question because if one person or one party is sort of falls off the face of the earth, does that,
Yeah, you would want to make sure you had a sufficient number of M people. So if people randomly die, the asset's not lost forever. But another thing is, this is another example of how virtual currency is a bearer asset, and the possession of the key is paramount.
Yeah, but if any of you are interested in escheatment, there have been some great law review articles out there, really, really good questions. I think Drew Hinkes, one of our presenters, may have written one of those articles. Really excellent work.
Yeah, if you just I'll give Drew a shout out. If you just Google Drew Hinkes and Carlton Fields, you'll find his attorney page, and I think he has all of his publications.
Yeah, is there a question out there? Is that Jade? Does anyone else have a question for us? Well, let's see. We can. Let me just some additional banter with Chris.
Yeah, our laws are really complicated. I'll just give everybody a warning. Our laws are really complicated. They're really detailed, and we think we provide a great deal of legal certainty. So don't assume that just because you've heard something about Wyoming law that is.
Yeah, no, I'm here.
Oh, hey, Russell.
I'm here.
Yeah. No, we were just giving you a shout out.
We're giving you a shout out because you and we've been talking with you about the UCC laws here, and we're about to launch into this hypothetical. Yeah. And I wonder if there's some pearl of wisdom that you've gleaned from talking to us that you can share, that perhaps that you figured out that about the laws here in Wyoming that might make it easier for people to, not to put you on the spot or anything, but I know you have some pretty keen insights about what Wyoming is trying to do here.
Well, in the first place, I'm flattered to be part of the discussion at all and to be with all of you. I'm not sure I would consider it a pearl of wisdom, but I think that with the steps that Wyoming laudably has taken to step out in front of these issues relating to digital assets, it's incumbent upon people taking security throughout the country to make sure that they're taking a truly national perspective on the laws that are applicable to the transactions and the possibilities that different laws afford to help them protect themselves.
Yeah, that's really helpful, because although these laws have been passed in Wyoming and other jurisdictions are looking seriously at them, you know, they're really espousing best practices, right? A creditor that takes a security interest ought to have
some form of ability to either possess or control that asset. Yeah,
exactly, and that's, I think, that's what Wyoming's trying. It has codified in its laws.
Yeah. So with that, we will officially,
we're going to end our first session.
We're like 20 seconds off the nose, so right on the nose. So
yeah.
why don't we just pause for a bit, and then we'll allow people to join, and in 60 seconds or so, we'll launch into the hypothetical.
And when we launch, you're going to see a PowerPoint. So just so you know what our plan is, we've created a short PowerPoint that lays out the facts. The facts are going to be fairly simple, so it's not something where you had to read 5 pages ahead of time. Yeah. We're going to walk you through the facts. And frankly, as we walk you through the PowerPoint, we're going to discuss it along the way. So we look forward to seeing you in very, very short order. And we will hopefully have a very lively discussion.
All right. Thanks, everybody.
Thank
Hope
you.
you got something.
Yeah, thanks.